Brandon Ketron here, who will lead the show, and then Alan Gassman is coming later and will get in the way. The SLAT stands for Spousal Limited Access Trust. So, Brandon, do you have to be married to have one?
If you want to take advantage of this new law, you're going to have to be married to have one.
So, would I have
benefit a non-spouse with a SLAT for a significant other, but it wouldn't work well for this type of law that we're going to be talking about today.
I see. And do you have to be married before you have the SLAT?
Yes.
If I'm married to another puppet, can I be married to a puppet and still have a SLAT?
Maybe. I don't know if you could benefit a non-individual, but we have to look into that one.
Okay. Now, can I go to Nevada and form a Florida Slat and gamble? Maybe not. Okay, that was the pre-show entertainment. We hope that you enjoyed it. It was certainly better than the actual show itself, which will begin in just a minute or two, or maybe a second. Thank you very much. Hey, welcome to the new Florida Slat Law. I'm Alan Gassman, and this is Brandon Ketron with me. And as you can see, I'm taller than Brandon, but he's certainly more intelligent. I thought you were the straight guy. So anyway, we are going to talk about this new Florida law. It was recently signed. It will not take effect until July 1st. So hold your SLATs, don't sign them, don't fund them until July 1st. And we're going to tell you why the Florida SLAT is now a more flexible vehicle. This presentation does not qualify for continuing education credit, primarily because it's not good enough to qualify for continuing education credit. In 3 to 5 hours, you will receive an email. I would delete it immediately or forward it to everyone you know, because it will provide a video copy of this webinar. If you have questions, you can just click on the question panel there, the little inverted pyramid, and then type in your question, and Brandon will answer it if I don't know the answer. We have a Saturday series every Saturday at 11. You can interrupt your time with your family and watch one of our webinars and say, I can't talk to you right now. I'm watching one of the webinars about business and tax, and it's mostly estate planning. June 9th, planning for Orthodox Jewish families. We're definitely looking forward to that. It's part of a diversity series for the National Association of Estate Planning Councils. And on June 2nd, a not-so-free 90-minute webinar on the Florida SLAT in much more depth. So let's go forward here and talk about, Brandon, do you want to explain what a SLAT is? I know we have members of our audience who are kind of new to this, so it's good to have a reminder.
Yeah, so a SLAT, as you mentioned earlier, as the puppet mentioned, it was a spousal limited access trust, sometimes referred to as a spousal lifetime access trust. But essentially what this is one spouse establishes a trust that's for the benefit of the other spouse and their children. So I set up a trust. It's for the benefit of my wife, Emily, and our children. And Emily can receive distributions during their lifetime. Upon Emily's death, it's held for the benefit of my children. That trust is not going to be subject to my creditor claims, my spouse's creditor claims. It's not going to be subject to estate tax. So it's a really good vehicle for married couples to transfer assets to trust, get them outside of their estate, but still have some indirect access to that trust. So it's something we use very often, and this new law has made it even more flexible and better, and we'll talk why that is.
So we're going to use some terminology. The grantor spouse is the one who establishes and funds the SLAT, and the beneficiary spouse is the beneficiary of the SLAT. So I could put $1 million, if I had $1 million, into a trust for my wife, Marcia. Marcia can be the trustee. She can have the right to receive whatever she needs for health, education, maintenance, and support. even if she's the sole trustee, the trust will not be subject to estate tax in her estate, even though she can have the power to direct where it goes when she dies, as long as that power is a little bit limited. So it's a really nice arrangement. It's creditor proof. As long as I put the assets in the trust and I am not a beneficiary of the trust, my creditors can't touch it. And like I said, it's never subject to estate tax. And then the income tax on the income of the trust, if my spouse is the trustee of the trust, or if the trust has certain language in it, then all the income from the trust can be taxed to me personally on my Form 1040 or on our joint Form 1040. And that way we pay the tax on behalf of the trust indirectly, and that's not considered to be a gift under the gift tax rules. So the big question that comes up when we set up a SLAT that clients ask over and over again is, does that SLAT cost? No, that's not what the question that comes up over and over again. The question that comes up over and over again is, that's great. I'm going to put the $1 million in there for Marcia and our descendants, but what if I need it? And the answer to that is, if you set the SLAT up in a non-asset protection jurisdiction, such as Florida, and you are a beneficiary of the SLAT, then under state law, your creditors can reach into the SLAT. And if your creditors can reach into the SLAT, then when you die, it will be included in your estate for federal estate tax purposes. But conversely, if I set up a SLAT and I am only a beneficiary of the SLAT, perhaps if I'm added in by a trust protector, or if Marcia and I get divorced, which I hope is highly unlikely, then, or if Marcia predeceases me, then that's the big question that clients have. Can I be added back? And as I said, under Florida law, it's most likely that a creditor can reach in, and then the IRS says, well, Alan, if you can run up a bunch of debt and have it paid by the trust, that is a benefit. And as a result of that, most of the SLATs that we establish have been in Nevada, because Nevada is an asset protection trust state. Nevada law says a creditor can't reach in. So our typical SLAT says Alan establishes this trust for Marcia and their descendants, and in the highly unlikely event of a divorce, or if Alan's net worth goes way down and he's sleeping in his car because he doesn't have any other assets to provide him with housing, or if Marcia predeceases Alan, then he could be added back into the trust. His creditors still can't reach into the trust, even though he can be added back in, and therefore it should not be subject to estate tax in his estate. Brandon, anything you may add to clean that up or make it understandable?
No, I think you did a good job of explaining that. And, I think there's private letter rulings out there also that confirm that that is the case, that even if you're a beneficiary of a trust in a domestic asset protection jurisdiction, that it's not included in your estate as long as you're a discretionary beneficiary. So we'll get into a little bit more details about that, because that's going to be important here, to make sure we don't have this trust included in our estate if we are added back in as a beneficiary after the death of the beneficiary spouse. So that's really the main unanswered question right now, and we'll give you some what we know and what the current guidance is on that issue. But yeah, I think you did a nice job of explaining the overall terms of how the SLAT works and how it can be used.
Okay, so I've got a chart here, and it's a little bit deceptive. It's not completely accurate as I look at it, but let's go through it. If I set up a SLAT for Marcia, under Florida law, Marcia is the only beneficiary who can receive benefits while we are both alive. Otherwise, if I was possibly going to receive benefits during Marcia's lifetime, it would not work. On the other hand, if we set this slat up in Nevada, and by the way, I'm assuming that this is after June 30th of 2022. If it's set up in Nevada, then I could be added as a beneficiary, as a discretionary beneficiary during Marcia's lifetime. So Nevada's more flexible. Going back to, what about the divorce? Well, only Marcia can be a beneficiary as long as she is alive. So in the event of a divorce, I can't be added back into a Florida slat, but I could be added back in to a slat in an asset protection jurisdiction. Can a future spouse of mine be a beneficiary of the slat? And the answer to that is yes. Now, Marcia would never let me sign a slat that would say that my future spouse is a beneficiary, but many slats do say Marcia is the beneficiary of this slat, and in the event of a divorce, Alan's next spouse would be a beneficiary of the slat. So if this was my second or third marriage and I was putting my premarital assets into a slat for Marcia's health, education, and maintenance, and I lost her as my spouse for any reason, I would want my next spouse to be in there. And I know I would want that because my next spouse already told me that that's what she would expect for me to have in that trust. So then after the death of me, after my death, and everybody would pretend to be sad for a couple days, and then after that, they would realize that they're still my spouse and descendants are still beneficiaries, whether that's in Florida or in an asset protection jurisdiction. But then here's where Florida is going to shine. You get it? Because we're the sunshine state, so here's where Florida's going to shine. Okay, if Marcia predeceases me, which will never happen, by the way, then I could become a discretionary beneficiary of the Florida Trust, but I could not have a power of appointment over the Florida Trust. And Brandon's going to explain more about that. So I could not be guaranteed the right to receive a benefit from the trust, but I could be, we believe, a discretionary beneficiary of the Florida Trust if my spouse predeceases me. And we're going to talk about that. It's based upon a private IRS private letter ruling. Sorry, I lost my bearing there. In an asset protection jurisdiction, we think it's the same thing. We don't think I can have a power of appointment. So then, does the 10-year look back in bankruptcy rule apply? Some of you are lawyers and CPAs who understand the 10-year rule in bankruptcy. And I think both in Florida and in asset protection states, you're going to still have the 10-year look back rule. And then I don't know whether the governor signed the 1,000-year rule against perpetuities law. I don't think he did, Brandon. Do you have any information on that? I see.
Yeah, I'm looking to see if it's been signed right now. I know it's pending. I don't know if that was signed as part of this new law or if it's still pending. So we can look on that and clarify if anyone wants to know for sure.
Okay. So what this statute did, they amended Florida Statute 736-0505. And what they did was they said, if a contributor, a settlor contributor, establishes a trust that benefits his or her spouse for life, for the lifetime of that spouse, and the spouse predeceases the contributor, then the contributor will not be considered to be a contributor to the trust after the spouse dies. So for Florida law purposes, if I set up a trust that could benefit me, then my creditors can reach the maximum amount that a trustee would be able to give me. But now, if I set up a trust for the lifetime benefit of my spouse and she dies, since I'm not considered to be a contributor to the trust, my creditors cannot reach into the trust. And if my creditors cannot reach into the trust, and I'm only a discretionary beneficiary, then under the private letter ruling and general law that Brandon's going to discuss, the trust should not be subject to estate tax in my estate. Do I have that right, Brandon?
That's right. Yeah. And I think, it's going to be important if you flip back to slide 24 to just talk a little bit about the specific requirements here that are required to have this statute apply. And it's underlined here as number 3. This is the added language to the new Florida statute. So number 1, we have to have the spouse as a beneficiary for the lifetime of the spouse. At no time during the lifetime of the settlor spouse is the spouse beneficiary described in 736.01.03.19. That's basically saying that the spouse has to have an income interest in the trust or a principal interest to receive a presently exercisable right to receive distributions. It has to be a completed gift, meaning it's not an incomplete gift trust, or you retain some sort of veto power over the trust or retain some sort of control over the trust. These are completed gifts for gift tax purposes. And then the final section there, after the death of the spouse, then the settlor, meaning the grantor spouse, can become a beneficiary and is not considered to be the settlor of this new trust after death, and therefore not subject to creditor claims. So I think the most important thing to derive from this is we have to have that settlor spouse as a beneficiary for a lifetime. So if you have a provision in there that divorce kicks the spouse out, or if it's a floating type spouse provision, if the trust protectors could remove a spouse, then the statute may not apply. So you got to be careful when drafting and make sure you review your trust to cover all these bases if you're going to use this statute.
Okay, Brandon, why don't you take us through now the 2036A issue and the private letter ruling and what the heck we should do. And here, I'll give you control of the slides now.
Yeah, so we got a lot of questions on this. We wrote an article and everyone said, well, what about 2036A? If you retain the right, their A1, possession, enjoyment, or the right to income from the trust, would that not cause the trust to be included under 2036A? And that's a really good question. It's possible that it could be included. Where we come from is, well, we're looking at, well, what do they mean by a right to the trust income? Well, a right, according to Bloomberg V&A, is if you retain or reserve at the time of transfer an express or implied understanding that distributions would be made, and or a pattern could be established where there's an inference that distributions could be made, or that you had this prearranged type plan. So if you have the trust that says, I receive $1,000 a month for my lifetime, and the trustee is required to distribute that amount, that's certainly a right that would cause inclusion under 2036. If the trust says, I have to make distributions for the grantor's health, education, maintenance, and support, well, that's probably a right because that's an ascertainable standard. If the grantor is destitute or needs something for their support or needs something for medical expenses, then the trustee may be required to distribute those amounts, and that would also be a right under 2036. But what if it's completely discretionary? Does the grantor have a right if it's just completely left up to the trustee? Well, according to this private letter ruling, maybe not. You can see here, this private letter ruling in 2009 said that a trustee's discretionary authority to distribute income and or principal to the grantor does not by itself cause the corpus to be included in the grantor's estate under 2036. So what does that mean in layman's term? Well, if the trustee says if the trust says in the trustee's sole discretion distributions may be made, that by itself doesn't cause inclusion under 2036. But what about the duty of the trustee to benefit a beneficiary, to keep the beneficiary's best interest in mind? What if there's a pre-existing arrangement where the trustee is the client's best friend or the grantor's best friend, and they're definitely going to make distributions? What if the trustee is related? All those are issues you have to be concerned with and lean more towards, okay, maybe there is a right to receive distributions. So just to go through the private letter ruling in a little bit more detail to talk about the facts of this private letter ruling, that we think makes it clear that a domestic asset protection trust where the grantor is a beneficiary probably isn't subject to estate tax. Maybe not so clear under Florida law, but what happened here? So first of all, the trust was set up. It said that the trustee could pay amounts in its sole and absolute discretion to a class of beneficiaries consisting of the grantor's spouse, and the grantor's descendants. So the grantor is clearly a beneficiary, clearly has the ability to receive distributions, but maybe not the right because it's completely discretionary. The trust provided that upon termination that it cannot be paid to the grantor directly or to the grantor's estate or to creditors of the grantor. The trust provided that the trustee cannot be the grantor himself, cannot be the spouse or a former spouse, cannot be any beneficiary of the trust, cannot be a spouse of any beneficiary under the trust, or anyone that is related to the grantor. Maybe that's required, maybe not. I think certainly you cannot have the ability of the grantor to replace the trustee with the related individual. And it would probably be best that the trustee be independent if you are looking to rely on this private letter ruling. And then they even went as far as providing that the grantor cannot even remove or replace the trustee in this trust. So it was pretty far, very conservatively drafted trust, I think, compared to what most of us would draft typically for clients. Because typically we give the grantor the right to replace the trustee. Sometimes we make the trustee even related to the grantor. So if we're looking at this private letter ruling and want to be safest, I think the safest place is to have an independent trustee. Don't give the grantor the right to replace that independent trustee, and provide that distributions to the grantor are going to be completely discretionary. So Alan, any thoughts on that? And what is your thinking now as far as if 2036 applies if the grantor becomes a beneficiary after the beneficiary spouse's death?
In all honesty, I'm going to provide in this Florida slat that I would not become a beneficiary after my spouse's death unless I am added to the trust in the discretion of trust protectors who do not have any fiduciary duty whatsoever to add me. Because this private letter ruling is only a private letter ruling. It's a ruling that was given to one taxpayer in 2009, and the first thing it says is this is for you and you alone. It's not binding on other taxpayers. So while most likely, and in the opinion of some very outstanding scholars, the private letter ruling is well grounded. It's not been criticized in any literature that we could find. I would certainly not put it by an IRS auditor to take the position that I read the word right in 2036 to mean any right. And if you're a discretionary beneficiary of a trust, even though you're discretionary, there is a duty on the part of the trustee that if you're homeless because you lost everything because of a hurricane, that they really have to give you something. So that's the first thing I'm going to do. I'm going to say I'm not going to be a beneficiary unless the trust protectors add me. And then the second thing I'm going to do, just to be safe, is I'm going to say the trust protectors can't add you unless your net worth is under $2 million. Because you know what? I shouldn't need to get into this darn trust. But if I do need to get into the trust, I'll find a way to get my net worth under $2 million. So that's going to be the way to play it safe. And as you know, Brandon, that's how we've been doing our Nevada trusts.
Yep. And I think the important thing there too is, a lot of times the only reason why you would want to get back into this trust if something happens where you lose a bunch of money and you need access to it. And if you draft it to say, $4 or $5 million is the threshold where you're eligible to be added back in, then you're probably not going to be subject to estate taxes anyway, at least at the current exemption amounts. So, that can be, a good, nice way to provide a back door. And then the concern, if you're added back in and whether 2036 applies or not, maybe we don't really care because we're below the exemption amount anyway at that point in time.
And I just thought of one other thing to add to the next article. is then I can feel safer having the power to replace the trustee. And then also I can be able to toggle off grantor trust stat, or at least have a better chance of toggling off grantor trust status and having the trust pay its own taxes later, because you can't do that if you're a beneficiary of the darn thing.
Yeah, good point.
Yeah. So do you want to just mention, because we're running out of time, and I think what we've got for everybody here, we've got the private letter ruling, and then well, I think we've covered the issue well enough. I'm glad that we have until July 1st to figure all this out, because I'm not sure we're going to have in our SLAT that if the spouse beneficiary dies, any trust that could benefit the contributor spouse will be funded based upon a formula. And the numerator of that formula will be the maximum amount that you could put into this new separate trust that might benefit the contributor without being subject to estate tax in the contributor's estate, in case we goof up somehow. But that's going to be an important issue. So the biggest mistakes that people are going to make with these trusts are, first of all, they're going to provide that divorce divests the spouse, and then the spouse will not be able to benefit for life, and then the contributor will be considered to be the contributor, even after the death of that first spouse. And then so that's that. And then providing the trustee with the discretion to reimburse the contributing spouse for taxes during the life of the beneficiary spouse, I think that could deactivate the Florida statute, because I'm not supposed to be a beneficiary whatsoever during my life. And it's common for these, when they're set up in asset protection jurisdiction, even when they're set up in Florida, it's common to say that the trustee will have the discretion to reimburse the grantor, but I think that that is an indirect benefit. So even though the IRS has kind of said that's okay as long as they're not a pre-existing plan, I don't know that that tilts the pinball machine enough to hit the buzzer and say that your SLAT's not going to work for the surviving spouse. I don't know whether the trust protectors being able to add me during the life of my spouse would be acceptable. I think it needs to say that they can only add me after the death of my spouse. And then the other one, somebody said, well, you know, am I more likely to act differently if I'm the healthcare surrogate for my spouse, and we haven't been getting along that well anyway? And if she dies, I could become a beneficiary of the SLAT. Does she really want me, you know, to have the healthcare power of attorney? You know, he unplugs me, he unplugs me not. And then here again, any right to receive distributions after the spouse's death could implicate Section 2036. So are you just better off doing what you were doing in Nevada? It's simplest just to not be a darn possible beneficiary of a SLAT. I mean, you got a client with a $30 million net worth and they're going to do a 10 million SLAT. They got another 20 million left. Do they really need to be a beneficiary of the SLAT? Probably not. Probably not. They can, you know, the SLAT can still be the bank, the family bank. The SLAT can still buy assets from you. The SLAT could still loan you money at arm's length. The SLAT could still give all of its assets to your children. And, you know, maybe your children might be willing to gift you something if they were to receive $10 million from a SLAT. I don't know. Yeah. Brandon, any final words or slides that you want to cover?
Yeah, no slides. I just want to, you know, say that, you know, the statute is interesting. I think it makes clear under Florida law that creditors can't get in to the trust if, you know, if the grantor spouse becomes a beneficiary after death of the beneficiary spouse. So it's a good creditor protection vehicle. We know that's clear. But what's unclear is how this is going to be treated for federal tax law purposes, and whether this right to become a beneficiary would cause inclusion under 2036. So until we get more clarity on that point, I think it's probably safest to continue doing what we typically do, as maybe setting up these trusts in Nevada, having the donor spouse being addable as a beneficiary by trust protectors, but only in the event that their net worth falls below a certain dollar amount, or having that same similar type of provision in the Florida Slat, but only providing that that can occur after the death, rather than making the grantor spouse automatically become a beneficiary, or using a formula clause as Alan provided, so that you have a backdoor or a savings clause in a sense that the trust wouldn't even be funded if it would cause inclusion. So I think we just have to wait and see what happens here. And luckily we have a little bit of time, and maybe someone will apply for a private letter ruling, or there'll be a case that comes up that gives us a little bit more clarity on this issue. But until then, I just think we have to be careful with automatically including a spouse as a beneficiary after death.
Okay, so we have 3 questions, Brandon, and I want to answer them because they're really good questions. First, from Richard, and Richard, thank you very much for attending our webinars. I don't know how you have time to practice law if you're always attending our webinars, but I would invite you to give a webinar with us sometime if you want to pick a topic. Here's Richard's question. Can the settlor give the donee spouse a testamentary special power of appointment? It's e.g. that the settlor doesn't want it back, but may prefer it go straight to the kids. Absolutely. The donee spouse can have the power to appoint the trust assets to anyone and everyone other than herself, her estate, her creditors, or creditors of her estate. So no problem there, Richard. Thanks very much. Now here's one from Colton. And Brandon, what about 736-08145? Should we exclude that statute from triggering if discretionary reimbursement is a problem? So Brandon, my first question is, what the heck is 736-08145? I kind of forgot which one that is, if I ever knew.
I'm in the same boat here. It has to do with grantor trust reimbursement clause, and I think it's a statute that says that, I'm just kind of skimming it through here.
Yes, I agree, Colton. I would exclude it. That I think is the statute that says that if you set up a trust for, say, your descendants, and the trustee has the right to reimburse you, and that builds up all this money that they could reimburse you, then your creditors cannot reach that reimbursable money. I think it's
solely because of those facts, you're not considered a beneficiary of the trust, so your creditors can't get in.
So I think it's best to disengage that statute, and maybe even specifically say in the trust, the grantor cannot be reimbursed for taxes. Now, I'm sure there's going to be a lot of tax lawyers who disagree with us on that. But I agree, and that's one of those mistakes that we were talking about. But Brandon, here's the really good one from Margaret, and that is, if the grantor can be added back at a certain threshold, so you have a net worth of 10 million, and you could still be added back if you got a net worth of less than 2 million by the trust protectors. Couldn't that still trigger inclusion even if you are not actually added back?
Yeah, and I think to answer that, I think the distinction is that it's not an automatic add back if your net worth drops below a certain level. It's in the discretion of the trust protectors to add you back, which are independent third parties.
Yep, go ahead.
Yeah, and I think if it was automatic, you might have that risk, but because it's still subject to an independent third party being added you back, and then only again if your net worth is below a certain level, then I think that's safer than the automatic provision.
Well, Margaret, I think that it's the doctrine of independent significance. I could set up a trust to say that in the event that I divorce my wife, she'll no longer be a beneficiary of the trust. And the IRS has said, well, wait a minute. If you could just divorce your wife and she's no longer a beneficiary of the trust, then you have a 2036A power. And the case law says, and actually there's a revenue ruling that says if there's a legal separation or a divorce, that is an act of independent significance. So I would consider a net worth clause like that to be an act of independent significance. But you're going to have three. You're going to have first of all, you're going to be in an asset protection trust jurisdiction. Secondly, the trust protectors should not be fiduciaries. And third, the threshold. And I think that's pretty safe. But that was a great question and a good wake-up call, Margaret. Brandon, anything to add here at the end? If you have further questions, comments, or suggestions, we will wrap these into a follow-up article that we plan to publish next week on Lineberg Information Services. We may also post a similar article to Forbes, the Forbes blog, and then we'll be having the Lineberg webinar for those of you who are serious and professionals on this. But we really appreciate any questions, comments, or suggestions. I personally have nothing better to do, so I really enjoy having an audience. We're glad that all 5 of you were here for this. Brandon, anything?
Yeah, no final thoughts for me. So I think we can wrap it up.
Okay, we thank Kelly, our Director of Professional Education, who just gave me notice today. Her last day will be June 10th. So June 10th will be like a national holiday for us. Have a fantastic Memorial Day weekend, and may the rest of your day be billable or under the influence of alcohol, as long as you're not driving. Thank you.